let's jump into just a handful of the important evidentiary rules that will apply in this case and really all criminal cases. So first, evidence needs to be relevant. What does relevant mean? And of course, these are all quite technical terms of art, folks. So evidence is relevant. This is rule 401. We're doing the first handful of the 400 series of rules here. 401. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. So what does this mean? It means, well, any criminal charge, or for that matter, any legal defense, is going to be made up of discrete elements that need to be proven or disproven beyond a reasonable doubt, typically by the prosecution. So the jury, the finder of fact, is trying to determine whether or not these elements, these particular facts required for determination of guilt or not guilty, have been proven to the required threshold, typically beyond a reasonable doubt. So any evidence that helps them make a decision about whether that fact is more or less likely to be proven or disproven meets the first criteria here. There's another word for this criteria, and that is probative. So probative really means this first sentence. It's more likely, it's evidence tending to make a fact more or less probable to the jury, helping the jury determine whether or not a fact has been proven or not proven to the required threshold. And if we look at the relevant criminal charge in this case, the Alec Baldwin involuntary manslaughter case. Did I not say that at the start? This is all about the Alec Baldwin involuntary manslaughter case over the shooting death of Helena Hutchins, cinematographer Helena Hutchins, on the movie set of Rust. And he's been charged with effectively reckless manslaughter, involuntary manslaughter. This is the jury instruction for New Mexico involuntary manslaughter, 14-231, the essential elements. And you can see it's kind of a fill-in-the-blank form. One, the name of the defendant, so Alec Baldwin, and then you describe his actions, which the state will describe in a way that's consistent with recklessness. Recklessness meaning the knowing disregard of an unjustified risk of death to another person. In this case, taking what he knew to be a real gun, Alec Baldwin, taking what he knew to be a real gun, not ensuring it didn't have live ammo in it, pointing that real gun directly at Helena Hutchins, manipulating the hammer and arguably the trigger of the gun in such a way as to unintentionally but recklessly discharge a fatal bullet into Helena Hutchins. These are the basic elements. So any evidence that makes any of these alleged facts more or less likely is going to be probative evidence. That's the first half here. The second half really is related, but it's the fact is of consequence to determining the action. That just means that the evidence is addressing a fact that is one of these required elements. There's another word for that, and that is that the evidence is material. So we can take this long sentences here. Evidence is relevant if it's probative. It helps the jury determine if a fact is more or less likely, and it's material. It's actually touching upon some element of the criminal charge or the legal defense. So that's how we define whether or not evidence is relevant. And if it's relevant, here's Rule 402, if it's relevant, it's generally admissible, unless it violates, it's admitting it would violate the U.S. Constitution, a federal statute, other evidentiary rules, other rules prescribed by the U.S. Supreme Court, or presumably in New Mexico, the New Mexico Supreme Court, and so forth. But otherwise, unless it falls into one of these exceptions, relevant evidence is generally admissible. Now, there's, of course, more exceptions. Rule 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. So it's possible that you could have evidence that is probative, that is material, so therefore it's relevant, but it might also carry so much prejudice that the prejudice outweighs. substantially outweighs the probative or the relevant value of the evidence. So there's a balance here. If evidence is relevant, but only slightly so, and it carries a lot of prejudice, then it may be excluded as being excessively prejudicial. What do we mean by prejudicial? That it's harmful to the defendant. Now, of course, all evidence introduced by the state is going to be harmful to the defendant, generally speaking. That's why the state's introducing it, right? They're trying to convict the defendant. So it's not enough that evidence being offered by the state is prejudicial. Presumptively, it's all prejudicial to be excluded. It's not enough that it's merely prejudicial. It would have to be so prejudicial that the prejudicial effect substantially outweighs the relevant value. Or one of these other reasons: confusion, waste of time, or other reasons. So the rule actually reads, the court may exclude even relevant evidence if its probative value, its value in making a fact more or less likely, is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I expect we're going to see a lot of these arguments from the defense when they file their own motion in opposition to the state's intent to bring in Alec Baldwin's other bad acts evidence. They're going to say it's unfairly prejudicial, it's confusing, it will be confusing to the jury, it'll mislead the jury, it's going to cause delay, Your Honor, it's going to waste time, and we're really concerned about the court's time. Those are the kind of arguments we can expect from the defense. Now we're getting into the meat of things. So Rule 404 has several major sections, A, B, and C. B is the really important one here, but just to touch on it for purposes of completeness, Rule 404 deals with character evidence, other crimes, other wrongs, or other acts, often called prior bad acts. So first, character evidence, subsection A, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. The idea here is that you're on trial for a particular criminal charge that has particular elements to the criminal charge, and the state's burden is to prove each and every one of those elements beyond a reasonable doubt to the satisfaction of the jury. You're not on trial for some uncharged prior bad act or for just being a mean person. There's no criminal charge for just being an a-hole. Now, you may be an a-hole. That doesn't mean you're a criminal. Unfortunately, it's in human nature that if we see someone and we're aware of their character or bad acts or wrongs, that they're just generally a despicable person, it can bias us in favor of convicting on a crime, even where perhaps the state has not been successful in proving the specific elements of the criminal charge beyond any reasonable doubt. And we don't want to, the idea is that we don't want to be putting people in prison if we've fallen short of the required threshold simply because they're despicable people. So that's the character evidence prohibition.